NASCAR countersues 2311 and Front Row, and they really don't like this Curtis Pulk character. How's it going, y'all? My name is Eric. Welcome to Out of the Groove. Today is a great day. Why? Because today we get to read legal documents. Before we get started, I should disclose that I am not a legal expert by any means. I do cover NASCAR very closely, and I've been following these cases since they began last fall. Before we get into today's most recent filing, some quick background info to get everyone up to speed. In September, after 2 years of tenuous business negotiations, 13 of the 15 NASCAR Cup Series owners signed NASCAR's new 2025 charter agreement. 2311, led by Denny Hamlin, Michael Jordan, Curtis Pulk, and Front Row Motorsports, led by Bob Jenkins, did not sign. And last fall, they filed an antitrust suit aimed at NASCAR and CEO Jim France. Since then, both sides have made arguments. At least one in-person hearing has taken place. 2311 and Front Row scored a short-term victory when their preliminary injunction request was granted. The injunction allows 2311 and Front Row to race as chartered teams this season despite not signing the 2025 charter agreement. Their cars all have guaranteed entry spots into every single race, and they're eligible for charter payouts at the end of every race and at the end of the season. NASCAR has appealed that injunction result, but things are moving slowly. Obviously, the season has begun. We're 3 races in. Now we get to today. NASCAR has officially countersued 2311 Front Row, and specifically Curtis Pulk, saying the teams violated Section 1 of the Sherman Act. It's the teams, they say, that actually violated antitrust law. I'm warning you now, this is going to be wordy. I've read the entire 31-page document. I want to share some of the most notable passages that outline NASCAR's claims against the two teams, but I'm just warning you ahead of time. Going to be some serious reading over the next few minutes. NASCAR says 2311 Front Row, Curtis Pulk, and others joined together to collectively demand a larger share of the NASCAR pie than they've been getting. By agreeing to eliminate competition among the teams, counterclaim defendants were able to achieve this outcome. NASCAR was harmed as a result of the collusive, threatening, and damaging behavior of counterclaim defendants. These activities resulted in reputational and brand damage at a time when NASCAR was attempting to renew its most important revenue stream, its media rights. This passage towards the beginning I thought was quite interesting. Although NASCAR recognizes the value the charter model has brought to charter teams and is certainly willing to continue with the model on the terms mutually agreed to, NASCAR now finds itself in the ironic position of having to defend a model that NASCAR never asked for in the first place, and which it would be content not to have. NASCAR has already made this point, but they're basically saying, we'd be fine if the charter system went away. And that doesn't really surprise me. You know, the charter system, which dates back to 2016, was originally pushed more by the teams. NASCAR acknowledged that the teams needed something that would give them more value. At the time, ratings had steadily been declining, sponsor revenue was harder and harder to find post-2008 recession, so NASCAR agreed to create these charters, and they effectively gave them to all of the full-time Cup Series teams free of charge. But in the past 8-9 years, the charter system has gotten bigger and bigger. Those free 2016 charters are now selling for $25 to $40 million a piece. 2311, for example, has spent tens of millions of dollars to collect their 3 charters. They're looking to protect their investment. The teams want these charters that they've spent money on to be made permanent. They want a larger seat at the table. And NASCAR's like, whoa, that wasn't our original goal. NASCAR wants its teams to be financially stable, sure, but NASCAR certainly doesn't want to relinquish any of their power. But that's essentially what many of the teams were asking for during last year's charter negotiations. NASCAR says that if the original 2311 Front Row lawsuit is successful, they may be forced to eliminate the charter system entirely. They write, quote, "By claiming the charters are illegal agreements, plaintiffs have opened Pandora's box. Charters, as previously mentioned, contain a goodwill provision prohibiting a charter holder from competing in a stock car racing product that would be dilutive to the NASCAR Cup Series. In exchange, the charters grant the charter holder a guaranteed starting position in all NASCAR Cup Series events. Both of these exclusivity provisions have existed for over 9 years and have benefited both parties respectively. If the charters are deemed to be anti-competitive, then either charters will go away entirely or the cross-exclusivities that benefited both parties will be eliminated. That is not an outcome that NASCAR is seeking, nor is it one that NASCAR believes benefits the racing teams which have partnered with NASCAR and signed charters. But this is an outcome that 23XI and Front Row, through this lawsuit, could impose on all race teams and their owners. So basically NASCAR is saying, going back to the original lawsuit, if the teams win, charters will either go away completely or NASCAR will be forced to remove those exclusivity agreements. Again, I'm no expert. Obviously, I have no idea how this litigation will ultimately conclude, but I'd be surprised if the charter system were to disappear completely, just because there would be a lot of angry team owners who are not suing NASCAR who would see their multi-million-dollar investments effectively go down the drain. Eliminating the charters altogether still sounds like a bluff. To me, it sounds like an attempt to discourage other teams from potentially joining forces with 23XI and Front Row. But maybe I'm wrong. Who knows how far NASCAR will go should these lawsuits not go their way. But back to NASCAR's actual argument in this document, they really take aim at Curtis Pulk, Michael Jordan's longtime business partner, part of 23XI Racing. NASCAR alleges that Pulk threatened other teams and knowingly violated antitrust law. Pulk's individual role was at the very center of the plot to use collusive behavior to extract more favorable commercial terms from NASCAR in the charter negotiations. These strategies and threats included, but were and are not limited to, a group boycott and threatened group boycotts of NASCAR events, including televised qualifying races, negative media campaigns, meetings with at least one NASCAR media partner to affect ongoing NASCAR negotiations for a new media rights agreement, and threats/coercion to other team owners to not break ranks. NASCAR also says that teams, members of the Race Team Alliance, the RTA, discouraged outside owners from purchasing charters, specifically citing a quote from Dale Earnhardt Jr. on the Dale Jr. download. NASCAR says, RTA members also engaged in a scheme to deter new team owners from seeking to enter the Cup Series by purchasing a charter, preferring instead to consolidate their own positions by purchasing additional charters themselves. Former racing star Dale Earnhardt Jr., who owns a NASCAR Xfinity Series team, explained that although he sought to purchase a charter, the RTA told him that, quote, this charter that I want to buy is a losing proposition. It's broken, that I don't want to buy this charter now because it's not a successful business. These representations were false, as shown by counterclaim defendants' purchases of 2 charters only a few months later for tens of millions of dollars. Dang, NASCAR makes it sound like these teams are master manipulators. So, in a nutshell, NASCAR is arguing that Curtis Pulk of 23XI illegally joined forces with other race teams who are supposed to be their direct competitors with the sole collective goal of extracting better contract terms from NASCAR. It is true that publicly, Curtis Pulk and other members of 23XI have said not so nice things about NASCAR. NASCAR claims that Curtis Pulk actually met with a media partner and impacted NASCAR's media rights negotiations. I mean, that might be true. I don't know that. They also say Pulk was responsible for leading the boycott of a meeting that was required under the previous charter agreement, which maybe that's true. We do know that the teams boycotted a meeting with NASCAR. I don't know for a fact that it's a required meeting, but NASCAR says it is. Again, I'm not an expert on any of this. I'm just trying to share with you what NASCAR said, and I'm trying to contextualize it because the big picture has gotten a lot bigger. Ultimately, NASCAR in their filing today iterates that 23XI, Front Row, Curtis Pulk knowingly violated Section 1 of the Sherman Act. NASCAR is asking for injunctive relief in the form of eliminating the section of the charter agreement that would allow for guaranteed entry spots for every team. And apparently NASCAR's attorney, Chris Yates, spoke to some reporters earlier this afternoon and made it sound like settlement is unlikely. He He told reporters, quote, "This is not going to be a renegotiation of the 2025 charter. That's not going to happen. I don't see a great path to settlement, but obviously we will participate in the court-ordered mediation process." So, in conclusion, it sounds like NASCAR believes there are three likely outcomes. They don't want to settle. They don't want to renegotiate the most recent agreement. Instead, NASCAR believes, one, they could win the lawsuit. And if that happens, presumably 2311 and Front Row would lose their charters. Maybe they could race as open teams, or maybe they would bow out of the sport entirely. That's option one. Option two, NASCAR loses the lawsuit and would then be forced to revise part of the 2025 agreement, namely those exclusivity provisions. Teams would then be allowed to race outside of NASCAR. NASCAR might remove the guaranteed entry spots. That's option two. Option three, NASCAR loses the lawsuit and scraps the charter system entirely. I still feel like that's a long shot, but Chris Yates continues to throw that out there like it's a real possibility. So, I guess I have to take him at his word, but those seem to be the three outcomes NASCAR is preparing for. They're not planning to settle. They're planning to either win, or if they lose, they'll get rid of charters entirely or make a couple of modifications. But yeah, I don't know. I know that's an anticlimactic way to end this video, but like I said, I'm not an expert. I can't give any legitimate predictions. All I wanted to do here was share the latest with you guys, add the proper context, and let you think for yourself. Before we go, I'd like to add that 2311 and Front Row's attorney Jeffrey Kessler did just release a statement, a response to this lawsuit, countersuit from NASCAR. Kessler says, quote, "Today's counterclaim by NASCAR is a meritless distraction and a desperate attempt to shift attention away from its own unlawful monopolistic actions. Today's baseless filing changes nothing. We are confident in the strength of our case and look forward to presenting it at trial." Thanks for tuning in, folks. Leave a comment down below. We will continue with the legal updates as necessary, but I've also got some other racing videos planned for this week and this weekend at Phoenix. I will talk with y'all again soon. Thanks for watching, folks. Hope you have a great rest of your afternoon.